I'm going to make a start since we've waited a couple of minutes already. So hopefully people can join as we go through. But today I'll be running this webinar about running a giveaway for your competition for your business. My name is Nguyen. I'm a senior associate at Gladwin Legal. So a little bit about us. So Gladwin Legal is a law firm that specializes in retail law. We work with a lot of retailers, like startups and small businesses, to large retailers and franchises as well. I'm a senior associate. I've been working with Gladwin Legal for 7 years now. A lot of my expertise lies in commercial law, e-commerce, intellectual property, and of course, trade promotions. We've won a couple of awards, as you can see on this slide. So if you have any questions about any business-related matters, we can usually assist. Feel free to contact us if you have any questions. So today we'll be talking about what is a trade promotion. So when I refer to competitions and giveaways, generally, if they're a game of chance, they're known as a trade promotion. So that's what I'll be talking about today. I'll be talking about when you need a permit, consequences of not having a permit or not complying with requirements of permits. When do you not need a trade promotion permit? What you need to know for larger prize pools and car and travel giveaways, drawing the prizes and whether you need an independent scrutineer and any other requirements there, announcing winners and publishing winners, advertising requirements and record keeping. So let's start with what is a trade promotion. A trade promotion tends to be a key marketing strategy for a lot of businesses. They're competitions of chance where there's no skill involved in selecting a winner. For a trade promotion to be considered a trade promotion, or a competition to be considered a trade promotion, the trade promotion needs to be linked to the sale of goods or services. And you can't charge entry to the competition, but it can be linked to the purchase of a good. So for example, if you have a store where you're allowing people to purchase clothing, you can link that to a free entry into a trade promotion giveaway. And that would be considered a trade promotion. So SMS entry has special rules as to costs, but usually you can't charge for entry. The purpose of trade promotion regulations is most likely to regulate gambling type events. There are definitely benefits to businesses being able to run trade promotions as marketing strategies. So the government has implemented these requirements just to deal with that kind of issue. They are different from lotteries or public lotteries, as the requirements for public lotteries are a lot more strict. Currently, there are only 2 public lottery permits granted in Victoria, one being Tattersalls and one being Intralot Australia. So it is quite challenging to, I suppose, comply with the requirements and also to be granted those lottery permits, which is why we have trade promotions here to allow everyday businesses to run giveaways in a regulated way, particularly to regulate the risk of gambling. So many businesses use trade promotions to collect potential customer or marketing details. If you do this, we really suggest that you have these specified as clear terms in your terms and conditions, because there are specific requirements in the legislation that requires it requires promoters to not use entrant information except in accordance with the purposes stated in the terms and conditions. So it's really important to have terms covering that. Another requirement for a trade promotion is that each entry has to have an equal chance of winning. So if you're thinking of implementing a competition where there are tiered levels of entry, so for example, a premium entry, which is worth more than another entry that's not allowed. So I'm going to talk about 2 categories of trade promotion today. They're not officially categories in legislation, but in our experience as lawyers, we often see 2 particular types of competitions a lot more frequently these days. I will note that there is also an instant prize trade promotion, which has different rules. For example, like the Macca's Monopoly is a recent example of that, where you can instantly win for example, small fries or something like that, by receiving a unique code printed on packaging. We won't be covering these today, so they are quite specific, but just keep in mind that these can be trade promotions as well, and they do fall under specific requirements. So the two categories that we talk about today will be goods-based and subscription-based trade promotions. A goods-based trade promotion is sort of the normal everyday trade promotion that you would see in your day-to-day. For example, a retailer that sells clothing who wish to run a competition or giveaway to promote brand awareness and boost their social media pages might run a trade promotion where a customer buys something in store, online, and they receive a free entry into the competition by virtue of that purchase. Another example would be where you have an Instagram post promoting some product or your business, and to enter the competition, you require entrants to tag a friend in the Instagram post comments, and then you randomly select a winner. These are generally smaller in scale. So for example, you could win a voucher or a cash prize for this type of competition. A subscription-based trade promotion is becoming more common. This is something that is somewhat new. You might have heard of LMCT Plus, which runs competitions that are based on a subscription. Basically, they're businesses that offer a membership or subscription for purchase, which gives customers access to, for example, a discount portal or other benefits. So basically, because as I mentioned before, trade promotions need to be linked to the sale of a good or service. In this case, the service would be the purchase of the subscription. The service is the provision of the access to the discount portal or other benefits. And the bonus for purchasing this membership is that they receive entry into a trade promotion. Usually these are for a car or another large value prize. So these are competitions based on a subscription. They're ongoing, and they run the trade promotions each month, for example, and each month there is a new trade promotion that the member will gain entry into. This is somewhat controversial just because of the fact that trade promotions do need to be linked to a good or service. In our experience, the South Australian Authority do not grant permits for these types of competitions, as they don't consider the provision of access to a discount portal or similar a valid service. There is a risk that the ACT or New South Wales, which are two of the most common states that require trade promotion permits for this type of thing. There is a risk that those states may also follow suit, but so far we haven't had any issues getting permits for this type of competition in those states. But just keep in mind, if you're planning on running a subscription-based trade promotion, that this is a potential risk. So key considerations when considering running a trade promotion. So firstly, what is the goal of the competition? Is it to raise brand awareness? Is it to gain social media likes, to promote a particular product or event, or is it to reward existing customers? Because these kind of questions do come into play when you're preparing your terms and conditions for the competition. What is the prize value and what states will it be run in? This is tied directly to the next question, which is what is the budget for the competition? So the scale of the competition has an impact on how much the competition will cost to run, because the permit requirements, the permit costs depend on the scale of the competition, particularly the prize value. And of course the states, because that would directly affect whether you need to apply for a permit in a particular state or not. And finally, what platform or manner will the competition be run? So it's important to consider what platform you're running the competition on. For example, social media may be subject to that particular social media platform's terms and conditions. For example, if you're planning on running a share to win or like and share to win competition, on Facebook, this isn't allowed under their terms and conditions because users can't use their personal timeline to promote a business. So things like share on your timeline to enter or share on a friend's timeline to get additional entries would not be permitted. Similarly, or not really similarly, but Instagram does require particular wording to be included in the terms and conditions to clarify that Instagram doesn't endorse the competition. So depending on the platform that you're using, it's important to look at their terms and conditions when working out what you need to include in your terms. So when do you need a permit? As a general rule, you'll need a permit if it's a game of chance and if it is an Australian-wide competition and the total prize pool is above $3,000. I'll go into more depth about each state's requirements shortly, but this is the general rule. If you're just a retailer, you're planning on running a competition, keep in mind you probably need a permit if these conditions are met, but there are other circumstances where you might need one as well. If you do need a permit, you'll need one for each competition you do, and this can be pretty costly, particularly if you're thinking of running a subscription-based trade promotion where you're running a competition every month. Keep in mind you'll probably need a permit for each one that you do, so that means every month you'll need a permit. I would say for most states you do need a permit each time, except New South Wales does have this new method of obtaining a permit, which is called an authority method, which I'll discuss shortly. I will say ACT does have the ability to apply for a blanket permit, but these only apply for small prizes where the maximum value of a single prize is $1,000 or less. The total accumulated maximum prize value can't be greater than $100,000, and the maximum period in which multiple lotteries can be run is 12 months. So just keep in mind, I would say for most of the subscription-based trade promotion types, this blanket permit rule for the ACT won't apply because usually the prizes are a lot larger. But it is something to consider if you're planning on running a business with that in mind. Now this slide shows the different values of the permits and the requirements of each. I'm not sure if you can see this laser pointer thing, but let's start at the beginning. So when I'm talking about prize value here, I'm talking about the total prize pool. So for example, if you're running a competition and your first prize is $100,000, your second prize is $50,000, and your third prize is $20,000, your total prize value will be all of those combined. So it would be $170,000 in that example. So your total prize value has a direct impact on the cost of the permit and whether permits are required at all. So let's start at the top. Any value, so if the prize is any value, you're able to run a trade promotion in Victoria, Queensland and Tasmania without a permit. And there are obviously no permit requirements. If it's below the prize value, so down this row here, I've put the different values. If it's below these values, then in New South Wales, ACT, South Australia and Northern Territory, you don't need a permit. But keep in mind, even if you don't need a permit, you do need compliant terms and conditions. Each state, including the ones that don't require permits at all, they all have specific, very specific requirements as to what needs to be included in your trade promotion terms and conditions and how the competition is run for fairness. So even if you don't need a permit, I would highly recommend getting advice in relation to preparing your terms and conditions and running the competition just to make sure you're complying with all the requirements, because there are significant penalties for not complying. So I'll skip New South Wales for now because it's a bit different, but let's talk about ACT. So if the prize value is over $3,000, you do require a permit in the ACT, and the cost of the permit can vary from around $220 to, if the prize value is over $200,000, it can go all the way up to $3,586. If the prize value is over $5,000 in South Australia, you are required to have a permit. And again, it depends on the value of the prize, the cost of the permit, but it can range from $223 to $4,500-ish. And then in NT, it's a little bit different. If it's over $5,000, you do need a permit. But in the Northern Territory, if you don't have a permit from, if you do have a permit from another state, you don't need a permit specifically in the Northern Territory. So if you've gotten, for example, New South Wales or ACT permits, then you won't need one in Northern Territory, even if your prize value is more than $5,000. And then in WA, you don't need a permit per se, but if your trade promotion is conducted by electronic media, so if you're drawing the prize, for example, by a random number generator, then you do need to submit the terms and conditions to their regulator. They will only respond to the email if there's an issue with the terms and conditions, but they don't require a permit. And let's jump back to New South Wales. So if the prize value is over $10,000 in New South Wales, you do require a permit, which they call an authority. It's a little bit different because it's based on time, whereas each of the ACT and South Australian permits are based on each competition. But in New South Wales, basically you can get an authority for 1 year for around $400 to 5 years for $820. And then it'll be active for that entire period. Multiple promotions can be run under one authority. So this is a good thing because you won't need to necessarily obtain a permit and pay permit fees for each competition you run. You just run it under one single authority, but you do need to lodge the permit rules for each competition at least 10 business days before the competition starts. But they won't reply unless there is an issue with the terms and conditions. So let's talk about the turnaround time. So normally we do find that we are able to get permits quite quickly within a couple of days, but it does depend on how busy the regulator is and everything like that. So normally I'd advise to give yourself at least 1 month before the commencement date of the competition to get all your permits in order, just because if there is an issue with your application or with your permit, that gives you time to fix it. And I would say the turnaround time can, they say to give at least 2 weeks to get those permits, although I will say in our experience, we can get it quicker. But for South Australia specifically, it will take at least 2 weeks to get the permit unless you pay the premium fee. And the premium fee is quite significant because it can be approximately double the normal fees. So if you have a competition that's more than $200,000 and you need to pay for a rushed permit, it could be like around $8,000, $9,000 for that application. So it's quite significant. And that premium fee will allow you to pay for a license to be granted within 5 business days of when they receive your application. So what are the consequences of not having a trade promotion permit? Well, each state has different penalties. If you run, let me turn off this laser pointer. If you run an Australian-wide competition, then this does mean you could be liable under numerous state laws. So it's quite important to make sure you're compliant with all the state requirements if you're running an Australian-wide competition. In South Australia, anyone who acts dishonestly in connection with a trade promotion lottery is guilty of an offence. The maximum penalty could be $50,000 or 2 years imprisonment. So it is quite a serious offence if there's dishonesty in relation to a trade promotion. If the trader, so if your business is guilty of an offence and receives a penalty, then the same could apply to each member of the management committee, the board of directors, the CEO, or any employee responsible for the conduct of the lottery. So you could be personally liable in South Australia if there's dishonesty. So please keep that in mind. In New South Wales, an authorised officer can issue penalty notices for breaches of the requirements of trade promotions in New South Wales, which can vary from $220 to $1,100 per offence. There are also some specific penalties depending on each of the breaches. So for example, failure to award the prize to a winner of a competition can attract a maximum penalty of $5,500. It is a defence if you've made reasonable inquiries to contact the prize winner, but they can't be located. But that is an important one. Make sure it's covered by your terms and conditions as well, that it's really clear that that there's a way to, I suppose, redraw the prize if it's not claimed. If a person associated with the conduct of a trade promotion converts the prize for their own use, there's a maximum penalty of $22,000 or imprisonment for 5 years or both. So that's a key one. Make sure you're not using the competition only to take the prize for yourself. If a person with the intent to defraud conducts a trade promotion, so that not all participants have an equal chance of winning, the penalty could be $5,500 or 6 months imprisonment or both. So there are quite serious consequences for running a competition, mainly dishonestly. So please keep that in mind. Make sure competitions are run in a fair way. There are also some advertising provisions or advertising requirements for trade promotions, which I'll talk about a little later, but the penalty for breaching those is the maximum penalty for breaching advertising requirements is $5,500. In the ACT, there are also penalties for running unlawful competitions, which can include fines and imprisonment as well. So I'm not going to go through every state's consequences, but keep in mind they can be quite serious. So when do you not need a permit? A lot of our clients will come to us and they say they want to run a competition to promote their business in a very cost-effective way. Especially for small retailers, this is pretty important because the cost of running a competition can be great because you not only have to get the prize, you not only have to pay for the permits, but also for the prizes and for the legal advice. So there are a couple of key ways that you can, get around needing to obtain a permit. For example, you could switch to a game of skill. Basically, if you add some kind of skill component to the competition, so rather than it being a random selected winner, if you have it so that it's a judged competition, for example, a tell us in 24 words or less competition would be considered a game of skill if the winner is judged based on their response. Keep in mind you still need well-drafted terms and conditions for a game of skill, just so that it's really clear that it's a game of skill and not a game of chance, and to deal with any potential disputes, and also to deal with, of course, all that marketing permissions and privacy policy requirements that come with collecting customer details. So keep in mind, you'll still need that, but you won't need a permit if you run a game of skill, because a trade promotion is only considered a trade promotion if it's a game of chance. I will say that many businesses don't want to add a skill component because from a practical perspective, businesses don't want more barriers to entry. Usually the purpose of a trade promotion would be to gain some kind of engagement on social media or something like that. So adding this requirement makes it a little more difficult to get people involved. But it is a way to, I suppose, avoid the need for getting a permit. Another option is to limit the states that your competition will be run in. If you limit the states to those that I mentioned above previously to states that don't require permits, such as Victoria, for example, then obviously you won't need a permit in that circumstance. The other option is to have a low value prize. As I mentioned, the rule of thumb is if it's below $3,000, then you generally don't need a permit. So if you have a low value prize, and keep in mind this is the total prize pool, not just a single prize, but the total prizes. If it's below $3,000, then you won't need a permit. If you don't want to have to send a copy of the terms and conditions to the WA authority, then you'd have to not run the competition by electronic media. And just keep in mind, even if you don't need to obtain a permit, you still need compliant terms and conditions. Every state requires this. So larger prizes, what are the requirements? So a couple of specific types of prizes do have very specific requirements. For vehicle prizes, some states such as the ACT require an independent valuation for second-hand vehicles or evidence of RRP for new vehicles. The prize value that you include in your terms and conditions needs to match up to that valuation. So they won't approve your permit if you have obtained a valuation from a dealer or something like that, and if that valuation doesn't match up to the total prize value or the prize value you've put in your terms and conditions, then you will not get the permit. And there are also specific details that need to be provided in your terms and conditions for travel prizes, which I'll discuss shortly. Another note is that the winner of the prize must not incur a cost to accept a prize. So that's a specific requirement in both Victoria and ACT. So you can't charge, for example, a delivery fee or administrative fee to deliver the prize other than trivial costs. So it's quite important to specify what exactly the prize is and note any additional costs that might be payable, especially in relation to a vehicle prize, just because, for example, if you're not including registration as part of that, that needs to be specified clearly in your terms and conditions, as long as you're not charging, for example, an additional cost that doesn't have to do with, well, I suppose if as long as you're not charging an additional fee rather than a cost that you're incurring to deliver the prize. This slide basically outlines the requirements in the ACT if you're trying to give away a vehicle. So I'll go into a bit more detail here. So for secondhand vehicles, including watercraft and trailers and caravans, if you're giving away one of these types of vehicles and it's secondhand, then you need to provide an independent third-party valuation certificate. It has to be provided by a valuer or finance company or similar. The certificate has to include a list of any and all modifications, a declaration that the person providing the valuation has physically inspected the vehicle, a definitive value for the vehicle, and include either the company or person who conducted the valuation. It has to provide their ACN or ABN. So what's not an acceptable valuation certificate includes a certificate that is provided by a person whose core activity is not the valuation of used items, including motor vehicles, or a valuation where it's solely based on estimates from other platforms offering online valuations. So keep in mind the person who's valuing the vehicle needs to physically inspect it. Estimates online are not sufficient. Let's see. The valuation certificate needs to include a declaration that the information is true and correct at the time of inspection, signed by the person who physically inspected the vehicle. And it also needs to include a description of the vehicle, such as the condition of the interior, exterior, and any items that may increase or decrease the value of the vehicle. For new vehicles, if they're obtained directly from a dealership or manufacturer, then you need to provide documentation to validate the RRP. This could be in the form of a sales invoice, receipt of sale, or a statement quoting the RRP, that kind of thing. We have found that in the ACT, if you don't provide this, then you won't be granted the permit. So keep in mind that you need to get this valuation for both when you're considering the costs of running the competition and also the timing of the competition, because you might need extra time in order to obtain this valuation before you can commence the competition. For travel prizes, there are specific details that need to be included in your terms and conditions. Make sure you have this information ready in time for your lawyer before the competition starts. Otherwise, there'll be delays in your commencement time. So the information you need to provide is whether the winner can transfer the prize to another person, how many people are included in the prize, the class of flight, so whether it's business class or economy, travel dates, whether there's a set departure point, or if there isn't a set departure point, how that would work. Airport transfers, whether they're included and whether there's any limitation on transfers. Is accommodation included? And if it is, then you need to provide the name of the hotel, the location of the hotel, and any the quality of it. For example, whether it's 5 stars or not. Whether meals are included is something that you need to include in your terms and conditions. Is spending money included? And if it is, how much is it? And whether there are any limitations or restrictions on use of the spending money. And whether any other travel expenses are included, for example, travel fares within the destination country. and also whether any other terms and conditions apply to the prize. So some competitions which have a larger prize value do require an independent scrutineer to oversee the drawing of the prize. In New South Wales, an independent scrutineer is required for total prize values of over $10,000. They don't need to have specific qualifications as a scrutineer, but they do need to be independent and not benefit from the draw in any way. So the specific requirements in New South Wales are that they have to, except for their role as a scrutinizer, they must not be concerned with the management, conduct, or promotion of the trade promotion. They must not be a director, employee, or otherwise employed by the benefiting business or the promoter, and they cannot have any interest or relationship, personal or commercial, with the benefiting business or any person employed by the benefiting business, which might be or appear to be incompatible with that person's independence. So basically, they just have to be independent. They don't necessarily have to be qualified. In South Australia, the requirements are a bit more strict, but the prize value requirement is higher. So you only need an independent scrutineer in South Australia if the prize value is over $30,000. I will just remind everyone that if it's a membership-based trade promotion, then it is likely that you can't run the competition in South Australia because, as I mentioned earlier, these competitions are not considered true trade promotions in South Australia. But if you are running a competition in South Australia where the prize value is over $30,000, keep in mind you do need an independent scrutineer. The scrutineer must not be associated with you as the promoter or involved in the conduct of the trade promotion, and must either be a commissioner for taking affidavits in the Supreme Court, a justice of the peace, a notary public, or any other person authorized to take declarations under the Oaths Act, a person authorized by the minister to be a scrutineer. So if there's a specific person there, they can also act as a scrutineer, or if they're on the Australian government's prescribed list of persons authorised to witness and sign statutory declarations. Drawing of the prizes. So along with the independent scrutineer requirements, make sure you have sufficient detail in the terms and conditions about how you're drawing the prizes. For example, if you're doing a barrel draw, I would normally specify that you're going to print out all the entries if they're entries in real life or in person. You print out all the entries and put them into a barrel for drawing the winners at random. There used to be a requirement for some states to have an electronic drawing permit. So, for example, if you're planning on running an Instagram competition and you're going to select a winner by random number generator by assigning each of the entries with a number and then picking a number at random, then you used to have to get a specific permit for that type of drawing method, but that's no longer required. But keep in mind, South Australia requires that an electronic drawing system needs to include a random number generator. And if you're running the competition exclusively to Queensland and the draw is being conducted in Queensland, then you need formal approval of a random number generator system from the Queensland Lottery Department. It's quite specific, so I haven't seen it needed before, but just keep in mind if you're running an exclusively Queensland competition, you do need a permit for that if it's an electronic draw. Announcing and notifying winners. So requirements do vary from state to state. Generally, the rule of thumb is to announce the winners in the same manner as the competition was advertised. So for example, if you're advertising the competition predominantly online, then winners should be announced online. If you advertise by other means, then you should announce the winner in that method. So for example, in Victoria, for prizes valued more than $1,000, then you need to publish the names of winners of all prizes either in a newspaper generally circulating in Victoria or on the internet for a minimum of 28 days. or if the lottery or the trade promotion was advertised solely through a particular publication, then it needs to be notified in that publication. In New South Wales, if the prize exceeds $500, then the name of the winner needs to be announced in a newspaper circulating the area where the trade promotion was conducted, or by radio or television in the area where it was conducted, or by the internet, but it would depend on the terms and conditions of the trade promotion. So make sure to specify that clearly in your terms and conditions. For South Australia, for prizes over $250, the initial of the first name and then the last name and postcode of each winner must be published within 30 days of the draw. And where this publication needs to be made depends on the location specified in your terms and conditions. So make sure that that's clearly outlined. Advertising requirements. This is something that a lot of businesses forget are required. Some states do have specific advertising requirements. South Australia used to have really strict advertising requirements, but I believe it's a little bit more relaxed now. But still keep in mind when you're advertising your competition that there are specific requirements. I would suggest getting them reviewed if you can, or at least the legal copy should be reviewed just in case. Don't forget to include your permit numbers on all of your advertising. And for New South Wales, if you have received an authority number, that's the number that needs to go on your advertising. Let me run through a couple of the requirements. So in South Australia, major trade promotion lotteries must contain, advertising must contain the license number, how a person may enter the lottery, the nature and value of prizes to be won, and how and where to get a full copy of the terms and conditions. It's actually similar for minor trade promotions, so even those that don't need a permit still need to comply with those requirements. But the more specific or interesting advertising requirements tend to be that so advertising the trade promotion must not be such as to appear to a reasonable observer to be directed at minors or portray minors in participating in gambling activities. The advertising can't imply that the lottery can fix personal or financial problems or cover expenses or debts, and it can't imply that the trade promotion can increase social, sexual, or employment opportunities. Further, the advertising must not exaggerate the prizes or suggest that the chance of winning is better than it really is. It can't present the chances of winning in a manner that's false or misleading, or in a manner that can't be verified, or state that the skill of the participant can influence the outcome of the lottery, or associate the trade promotion with any excessive alcohol consumption. In the WA, there are some requirements if it's conducted by electronic media. If it is conducted by electronic media, then advertising needs to include a description of the prize of prizes, direct participants to the full terms and conditions, which is fairly simple to comply with. In New South Wales, the specific requirements are that advertising material must not encourage a breach of the law, must not depict children participating in the trade promotion or gaming activity, as they call it. It can't suggest that winning will be a definite outcome in participation, and it can't suggest that participating in the activity will definitely improve a person's financial prospects. So a lot of it has to do with making sure you're not encouraging sort of gambling activity amongst minors, or again, it's just tied to those sort of issues that come with gambling. Also make sure that you do comply with Australian consumer law, because that would just generally apply. So for example, don't engage in misleading or deceptive conduct when you're advertising the prizes or the chance of winning. Record keeping. So generally there are requirements for keeping records after each competition. So Normally, I would suggest the most onerous of these to ensure you're complying with all of the state laws. The rule of thumb is to keep records for at least 3 years. But if your prize is greater than $20,000, then Northern Territory does require records to be kept for 7 years after ending the competition. So keep that in mind. I would suggest then if your competition prize is greater than $20,000 to keep it for 7 years rather than the 3 years, unless you're not running the competition in the Northern Territory. The records you need to keep include information such as all entry forms and tickets, a list of entrants, list of prizes and their values, list of prize winners, records of publications of the winners, evidence of the prizes being awarded, and records relating to the income and expenditure relating to the competition. So that's everything for today. We finished a little bit early, so feel free to let me know if you have any questions. But other than that, I hope you all enjoyed this webinar. Thank you for coming. If you have any questions for me, feel free to contact me on the details on the slide. So megan@gladwinlegal.com.au, or you can call us on 1300 033 934 and ask for Megan. Let me know if you have any questions or queries. Otherwise, have a great morning. Thanks, everyone.